Hi everybody, I'm going to take you through the contract law. I'm going to talk you through the PowerPoint and I hope it will help you study for your test and makes it a little bit easier. So here we go. Well, here you see an overview of our Dutch private law. It is all published in a Dutch civil code and all the necessary articles you will need for your test will be also attached to your test. So you will never ever have to learn any articles. Most people are a little bit scared of our law book. They think, oh, it's so boring and difficult, but it isn't. It's really fun and it gives you answers to everything you need to know. So that's why I always say picture it like nice sweet cupcakes. Then it's not that scary anymore, you know? Then it's more fun. So what we use from the private law is of course not everything because it's a real big book, but we use mainly book 3, book 6, and sometimes the nerdy cousin I call it book 7. It has very special rules for special contracts. But basically we will need book 3 that has like the general laws. When can you participate in a contract? When do you have legal capacity? And then book 6 tells you everything about real contracting. And here you see again an overview of the Dutch Civil Code. It's a really big book. It's divided in books instead of chapters like we would do in a normal book, but actually it has a lot of topics and we will use a few of them to see and study our contract law. First thing we have to ask ourselves, of course, is like, what is a contract? And maybe you have in your mind a long, boring piece of paper with kind of a very hard to read language. But a contract, people, a contract is so easy. A contract is just an agreement between two or more people. Any agreement. And what can it be? Can it also be an agreement to go for a drink tonight or to go running with your friends in the morning? That's also an agreement. But there's one thing special about a legal agreement, and that is that it has legal effect. And that's the difference between an agreement to go running, to go for a drink, to app your mother, or whatever you do in daily life, and a legal agreement. A legal agreement is like the same. It is an agreement, an appointment, something that two people agree on, but you have legal effect, and that means you have the legal means to really get what you agreed on. So if you order an item and you pay a purchase price, you are entitled to get that item. And if for some reason it doesn't come to you, you're entitled to get your money back. You're not all alone when everything goes wrong. And that is the difference. And that is also why if you cancel an appointment to go to a birthday party or to go running at 8 in the morning, nobody will sue you. But if you don't pay your rent and you keep living in an apartment that you don't pay for, you will get sued and you will get thrown out, because that agreement is an agreement with legal effect, and agreements in daily life do not have that legal effect. You don't have to study the differences, it's just something you feel, and I won't bother you with it anymore. But this is an agreement. A contract in the law is simply an agreement between two people that has some obligations. And I'm constantly saying like between two or more people, and that is really what it is. A contract can only bind the people that are in it, the people that said yes to that contract, that says okay, like a marriage. Every contract is like a mini marriage, and a marriage is just a contract. So it's kind of the same thing. Two people say yes, they are together bound to that contract. They have to fulfill, to perform the obligations that the contract contains. Nobody else, and nobody else is involved but the parties, the contract parties. And then another question, like I already said in the beginning, when you hear the word contract, people think of a really long, big stack of papers with very difficult language. But is that correct? Is that what the contracts are? No, people, the contracts are everywhere around you. And that is why you are a very experienced contractor. You just didn't know there were all kind of legal articles about it probably. But every time that you buy yourself a drink, you go to the supermarket, you order a pizza, you buy clothes, you buy books, you inscribe, you register for your study. You probably have lighting, you have heat, you have water. All these things are contracts. You have internet, you have a telephone, all contracts. See, I could like scare you with it. So many contracts, you're like living in contracts. So contracts are everywhere. What can we learn from that? That is that there is actually no necessity to write it or sign it. Contracts are binding the moment two people agree on that contract, agree on an obligation. And of course, it's handy to write it down. It's handy to ask for a signature if you have an important contract, because then later on you can prove that you really entered that contract with that person and what the content of the contract was. But any contract, any agreement with legal effect that is made, has been made between two or more people, is legally binding. Whether you can prove it or not is step 2. So it is binding. There are no requirements for the setup. Contract. Mutual agreement with legal effect, binding for the people that said yes to that contract. Contracting comes in 3 steps. This is the whole contract law like in one slide. Contracting is divided in like 3 parts. First comes the formation. The formation is a way of performing 3 checks and to see if there really is a binding contract. Because it could be that there are 2 people that think they have a contract, but actually it isn't a contract. The consequence of that is that the contract law is not applicable if it's not a contract. So therefore we have to make sure that the contract is really a binding contract. There are 3 questions we have to ask ourselves to see if a contract is binding. First of all, like the marriage, is there an offer and an acceptance? Do you want to marry me? Yes, says the other person. And that is an offer and an acceptance. You see a Domino's menu here. That's an offer. If you click on one of the items, or you call on the phone, or you are there and say, listen, I would like pizza number 6, that is an acceptance, offer, acceptance. So that is when 2 people agree on something. Second step is legal capacity. People have to be able to participate in the legal process. I'll get to that. And then what they say should also be what they want. I'll get to that too. So we have 3 checks to check if the contract is binding. Step 1, formation. Secondly, we check actually what did parties mean? What did they want with this contract? You wanted to order a pizza number 6. It costs a certain price. That is the content of the contract. And we derive from that what are the obligations that the parties have to perform. Because a contract, if you make an agreement and you have to do what you agreed on, you have an obligation. You have an obligation to perform, we call it. So if you say, I would like to order pizza number 6, you have an obligation to pay the purchase price. Domino's has an obligation to give you the pizza. That's the way it goes. At the end, we have the termination, because a contract should end. We should not stick to it forever. And if both people perform 100%, it just ends. There is no problem. But a lot of times, people I see, especially, there is a contract, but one party performed and the other one didn't. We call that a breach of contract. So if you order your pizza number 6 and it is €7, but you only give €5, that is a breach of contract, because you should have paid €7, the entire price, 100%. You can imagine if there is not 100% performance from one of the parties, there's like a gap in performances, because they should be equal and not one a little bit half and one a full performance. That gap is the breach of contract, and that has to be filled before the contract can end. If you don't perform, basically you are liable for it. So you still have to perform, or you have to pay for the damages, and that's what I will tell you more about when we reach step 3. We're going to start now with the formation, the triple check, 3 checks. That's the first thing you do. Whenever there's a question about a contract, you always start with a triple check. You don't even care about the story or the people actually in legal affairs. You just first check, is this a binding contract? Check 1. Was there an offer and an acceptance? As you can see, also the Dutch Civil Code says an agreement comes to existence by an offer and its acceptance. If there is no offer or no acceptance, if one of both is missing or when they're both missing, there can never ever be a binding contract. So we need an offer and an acceptance. We need one, like if we take in our minds again the marriage picture, the two people that say yes to each other. We need two people to say yes to a contract. Next check. That is something you can maybe imagine, the legal capacity we call it. And that is the question, can you actually perform juridical acts, we call it. That's Article 332. It says, can you play a legal game actually? Can you be a participant in the legal world? You can be a participant if you're 18 and older and if you're not under guardianship. Very simple. So you cannot be a minor and you can also not be under guardianship. Guardianship, I'll explain your guardianship to you. Guardianship is always announced by a court of law, and that is if somebody cannot take care of its own affairs, somebody else will act in the future on behalf of that person under guardianship. That can be somebody with severe Alzheimer's, severe brain damage, somebody has fallen into a coma that cannot act on his own behalf anymore. So somebody else replaces actually that person. A person under guardianship can not participate in the legal world. He or she does not have legal capacity. That's one. If this would pop up in a case or at your test, it always very clearly says there was a deal between Mr. A and Mr. B, but Mr. B was under guardianship. And if Mr. B under guardianship would have performed a contract, would have, for example, accepted an offer, that acceptance is not binding, not legal. And therefore, we say like there was no acceptance. A person under guardianship cannot accept, can also not offer, so can never ever conclude a binding, legally binding contract. Same, kind of the same rule goes for minors, people under 18. The rule is if you are 18 and older, you can perform, you can participate, you have legal capacity. If you're under 18, you can only contract with permission of your parents. And to prevent everybody under 18 to have to go to a shop to buy like a drink or a pizza or a pair of pants with a note from the parents, the law presumes that you have permission if things are according to your age. But still, parents are allowed to object to bring back an item and to get their money back. So 18 and older, you're safe, and else you need permission from your parents. No guardianship, no minors in contracting. Legal capacity, check 2. Last check is also the most difficult check. It's a very, sometimes a very hard one to understand, but don't worry about it. We'll make it easy. Will and declaration. The law says your will and declaration in contracting should be the same. The thing is though, as you can imagine, your will is like inside of yourself. Nobody can see your will. What we only can see or hear is the declaration. And then we presume that it is also somebody's will. So if you are there at the Domino's again, you say, hello, I would like to order a pizza 6. That is your declaration that we hear. We presume that you also want that pizza number 6. The law says what you want inside and what you say, what comes out on the outside, should be the same. If you accept that offer from Domino's to order pizza number 6 and you didn't really want it, there is no acceptance and then there is no binding contract. So we need a matching will and declaration to have a binding contract. If the will and declaration do not match, we have a defective will. A defective will. A defective will can be caused by two things. It can have an external cause and an internal cause. The external cause is very easy to spot. Usually you have two parties in a contract, party A and party B. Party A points a gun at party B. Party B maybe signs a contract, enters a contract he didn't want. That is a threat, of course, and that is not legally binding. Also, fraud, for example, is not legally binding. That's what we focus on, fraud and threat. Very easy to recognize. Fraud is that you tell lies on purpose to persuade somebody else into a contract. If you do that on purpose, influencing somebody's will or somebody's declaration, you are doing the wrong thing, and it can never be a binding contract, because if you would not have pointed the gun, if you would not have lied to a person, they probably would have never ever accepted your contract. And therefore, an external cause of a defective will, so somebody threatens you, tells you lies on purpose, there will be no binding contract. That is easy to understand because it's very unfair and unjust too. We go now to the yellow part of this slide, the internal cause of a defective will. That is something else. That is when one party in a contract, so party B for example, party B has a mental problem or mental illness. That mental illness or mental problem might influence their will, might cause him to do things that that person would have never done without the illness. We see that in practice a lot with people who are suffering from like manic depression. In a manic state, people will buy too many things or enter into contracts that are way too expensive or way over their heads because they see everything too positively. Also, people with psychosis often enter into contracts under a psychosis that they would have never entered in their usual state of being. Another example is in working relationships with employees that suffer from severe depressions. In a spur of a moment, in a very bad moment, they might say, listen, I resign, I quit. And that might be caused by their depression. They would have not done it if they wouldn't have felt so depressed. So that is a different situation, because this is party B and we are party A. We, party A, cannot see inside the head of party B. So how can we tell if somebody has a problem or not? That is not that easy always, because maybe we buy something online or we buy somebody's car and the person seemed totally normal. We paid a good price for the car. There was nothing that should have made us doubt. And maybe later we figure out that the person was very depressed and never meant to sell their car. Should we then have to give it back or not? You know, you can already feel that this is a different situation. It's not as clear and not as unjust or unfair as the other one. There is an additional rule with people with mental illnesses, mental problems that have a defective will caused by that. The main rule is still valid. The person with the mental illness has a chance to say, listen, I will make an appeal on 333. What I said and what I wanted didn't match, so there is no binding contract. I did not participate in a binding contract. The other party though, maybe us, that did business with them, said, listen, but we didn't see anything that was strange about this person. We paid a reasonable price. We didn't do anything wrong. The person didn't behave strange. We want to appeal on 335 and justifiably trusted in what the other person said or displayed. And if so, if you have reason to justifiably trust in that person, if there was nothing you should have noticed about the state of mind of the other person, you have a binding contract. So this is an exception to that main rule 333. This like concept is really hard to grasp, because I know that it took me a long time to really get it. External causes, like somebody puts a gun at you, yeah, that's easy to understand. No, there is no contract. But a person with a mental illness that influenced their will and we didn't know about it, that is much harder. But it is very interesting, and you will see that in a case we have also in our weekly challenge. To sum it up, external causes never lead to a binding contract. Internal causes, If somebody displays something that you should have, or that should have been reason for you to worry or to doubt if this contract is correct, if this person is really sane, then you have to do something. You have to dive into it first. Then you cannot justifiably trust in somebody's statement. If there's no reason to doubt and you had a contract, there was a reasonable contract, not very disadvantaged for that person with the mental illness, there might well be a valid binding contract. So it can go both ways. At your test, this could occur. I could make a case where somebody has a mental illness and acts. It's not about finding the right answer, people. All answers will be good. It is about your IRAC. It's about your legal analysis. And your legal analysis can go left and can go right. That is not what I will judge you on. That is not what will give you points. What is important is that you can make your IRAC nice and good and sane and logic. So that is the next lesson, how to apply an IRAC, but it's not about the content of your answer, your conclusion. Then you know that already. This was very hard. I have also a nice example here of this. This is like a famous example. This is like the Beatles or the Rolling Stones in law. I always say, Mr. Eelman, Mr. Hin. Mr. Eelman put up his really nice house for sale and Mr. Hin bought it. Situation was like this. Mr. Eelman had a psychosis. He thought his house was haunted and he heard voices and he saw arms coming out of the wall and these voices threatened to kill him. They threatened to kill his kids. And this Mr. Eelman got so scared that he put up his house for sale. But he never told Mr. Hin or the real estate agents why he put up his house for sale. He asked for a reasonable price. He asked a price that was a little bit above market value even. So, good price, he asked. And he said, I want to go to the mainland. He lived on an island. And he said, I'm getting older. It's not really handy to live on an island. I regularly have to go to a hospital. My kids live on the mainland. I want to be closer to them. There was really nothing strange about that. Mr. Hin paid the price that Mr. Eelman asked, a little bit above market value, a good price. He didn't see anything. His real estate agent also didn't see anything strange about Mr. Eelman. They didn't notice anything that was odd. After a few months of living in the house, Mr. Eelman though got a subpoena and was summoned to come to court, where Mr. Eelman claimed he wanted his house back because he had been under psychosis. And it was true. Mr. Eelman had a psychosis at the time he sold the house. Article 333. His will was defected by his mental illness. If your will is defected, the main rule is there is no contract. Mr. Hindo said, I paid a reasonable price above market value. There was nothing in the behavior of Mr. Eelman that was odd or off or worried me. And this whole sale of the house was not a negative thing for Mr. Eelman. He had a good price. He could rebuy a very nice house. So also there was nothing that I did that was wrong. I could justifiably trust in what Mr. Eelman said. I want to make an appeal on 335. Justifiable trust. An exception to the rule of 333. An exception to the defective will. Who do you think won? If you would make an IRAC, you would weigh 333 against 335, and you will never know what a court is going to say. It's always very hard to predict, and that's why you also don't have to give the right answer, but you should be able to make a nice analysis of this case. In real, it all went up to the Supreme Court, and Supreme Court finally said, listen, Mr. Hin can keep the house. He justifiably trusted Mr. Eelman, and he could. Because he paid a valuable, good market price. He didn't see anything strange about the behavior. The real estate agents also didn't notice anything. The declaration of Mr. Eelman was reasonable, and there was nothing else they could have done. So Mr. Hin had to keep the house, and he was happy, and Mr. Eelman lost it, which was not really nice for him. This is the end of part 1. I'm going to go on with another video lecture afterwards, and I just want to sum up what we actually learned so far. We learned about contracting. A contract is a mutual agreement with legal effect, and you can set it up in any way you like. You can talk it, you can mime it, you can write it, you can dance it. There is no requirement for the setup. It will be binding the moment there is an offer and an acceptance. It's handy to write it down, to get a signature, and to really make clear what your contract contains, of course, for proof. But the contract is binding at the moment two people agree in any way. What did we also learn? The contract is only binding for the people that are involved, that said yes to that contract, not to other people. Then we said we distinct 3 stages in contracting. The formation, where we check whether or not the contract is binding. The content, where we find out which obligations parties have, what do they have to perform. And then we end with the termination. If both people perform 100%, both parties perform 100%. The contract is done and over with. If both or one party did not perform 100%, we cannot end the contract before we solve that gap that exists between the 100% and the actual performance that was less. So we have to figure out who is liable for not performing and who has to pay the damages, and we will do that in the next part. We went all the way through the triple check that belongs with the step 1, the formation, and we saw that we have to check 3 things. Is there an offer and an acceptance? If so, the people involved, did they possess legal capacity? Could they play the legal game? Are they allowed to function in the legal world? If the person is a minor or under guardianship, there is reason to doubt. Person under guardianship can never participate in the legal world, a minor only with permission from the parents. And then we had the difficult thing of will and declaration. They have to match, else the law says there is no contract. 333. If you have a defective will, there is no contract. What can cause a defective will? Somebody from the outside can cause it. They can lie to you, they can point a gun at you, threaten you, or something like that. There will never be a contract. Then we have the situation where your own mind can cause a defective will. A mental illness can cause a defective will. There is no contract. But there's an exception to that. If your will is defected by mental illness, but the other party didn't have any reason to doubt you and your declaration, they justifiably trusted you and they could, and then there is a contract. So like in will and declaration, the battle in a court is always weighing, is it 333 a defective will, or is there somebody that had a right to trust what the person said with that defective will, and is there a contract or not? So it's a weighing of these 2 articles, and there is no black and white answer. It's always very grey, especially these will and declaration cases. For you, it's important to later be able to apply an IRAC to it. You cannot like give a right answer. It's really an interpretation of facts and how you weigh the articles. So I'm just asking you to perform a legal analysis, and whether you end up with 333 as like the winner of the case or 335, that is not important. I'm going to stop here with part 1. I'm going to continue with part 2 in the next lecture, and then I will go to the content of the contract and the termination of the contract. I hope it was useful for you, and I hope to see you at the next lecture.